SJC-11719, Commonwealth versus Mazariego.
Good morning, Your Honors. Kathleen McCarthy for Mr. Edwin Mazariego. Your Honors, I would like to start with the issue relative to the admission of the defendant's statements. In this case, there were two times or two separate dates that Mr. Mazariego was interviewed. One was April 29th of 2010, and one was May 17th of 2010. It's the defendant's position that what occurred during the April interview rendered what happened in May involuntary. This was the subject of a motion to suppress that was litigated, and the judge, who was the motion judge, not the trial judge, denied the defendant's motion. Then when we came to trial, there was a motion in limine that was filed by trial counsel, and he moved to suppress the April 29th interview, which the judge denied, saying that the judge who heard the motion to suppress had ruled that it was voluntary. Our position was that the judge, on the day of the motion in limine, the trial judge, should have actually addressed the voluntariness of the initial April statement, and it was error not to.
But the second judge had already considered the voluntariness of the April statement.
No, he actually just reviewed the findings of the judge who did the motion to suppress.
Well, that's what I mean. The judge, I'm sorry, the judge who did the original motion to suppress actually considered the voluntariness of the April statement.
Well, he ended up ruling on it, but it wasn't part of the motion that was filed by defense counsel, because at that time, my understanding of the record is that he did not anticipate that the Commonwealth was going to use anything from the April 29th statement. But then when the trial came about, he was under the impression that the Commonwealth was going to use a portion of the statement, or the trial judge allowed a portion of the statement. And basically, there was a picture presented to the defendant of the victim during the April 29th interview. And in that interview, the defendant denied knowing the victim. So that information, which was garnered at the April 29th interview, was actually used at trial. And defense counsel was saying, look, I didn't anticipate that anything from the April 29th statement would be used, because during the April 29th statement, the defendant denied involvement with the killing of Ms. Libby, and there was also tangential conversation about another incident in a shooting that had occurred. So when counsel realized this, he then filed a supplemental or a motion in limine relative to voluntariness, and he did raise two additional issues which weren't really addressed in the initial motion to suppress. So that being the case, I think that the judge should have considered everything in voluntariness anew, as the law does allow that to happen. Speaking about the circumstances surrounding the statements that were given by the defendant, it's our position that these statements were not voluntary because of the conduct of Detective Mazariego during those conversations.
This would be during the April conversations.
Yes. During the April conversations, it's our position that when Mazariego started the conversation, he told the defendant, if you tell a lie or something like that, that it's not real, in order for you to tell me something, you know that nothing you say can be used against you. So the defendant was under the impression, as he stated to at the motion to suppress, that he did not think that Mazariego could lie to him during that conversation. This was followed up by, I think that was the beginning and kind of set the tone for what became more coercive and misinformation that was relayed to the defendant during that conversation.
Now, was this a Spanish-speaking police officer? Is that?
Yes, it was a Spanish-speaking police officer. I believe there were two officers there, and one of them was Spanish-speaking and spoke in Spanish to the defendant. However, I will point out, and this was actually raised in the motion in limine, that at the beginning of the interview, when Rosario was explaining to the defendant the role of the attorney, he said, is there any part of what I'm telling you when he's going over Miranda that you don't understand? The defendant says, yes, but can I ask you a question right now? And the attorney, how is that? The defendant says, in other words, excuse me, what I mean is whose side is the attorney on? Then Rosario says, okay, I didn't understand the question. The defendant says, because you're telling me that if I want to, I can answer the questions, or else an attorney will come. So that was at the beginning of the April interview, and I suggest what that indicates is that the defendant was confused about what the role of the attorney would be. And Rosario didn't take the time to explain that, no, the attorney is on your side and he can help you with questions and whatnot. He just kind of barreled on through the questions that he wanted to ask.
So is your point that he didn't understand his rights?
Yes, well, that is part of it, that the waiver, the Miranda waiver, was not knowing and voluntary because he did not understand the role of the attorney. And that's clear at the beginning I'm sorry, of Rosario's interrogation of the defendant. And keeping in mind that the defendant, who had been in custody on an unrelated matter in the Worcester House of Correction, was brought here for the interrogation. The reason he was brought was because Detective Rosario, the Worcester Police Department, had got information that my client had apparently been involved in the shooting of this victim, a prostitute, a few years earlier, so they take him in. I suggest that the initial conversation related to the alleged shooting or shooting at my client, another witness who kind of put them on this scent to go interview my client, and another individual who was the actual, in our mind, in the Commonwealth theory of the case, was actually the one that inflicted the injuries and the beating on Miss Libby, who was at the scene. So my client, he wasn't a citizen. He had been held in custody on an unrelated matter. He came, it was a small room, it was windowless, and he's being interrogated. There were also
there were two interrogations on the 29th?
Yes, there was the
first one is sort of focused on this other matter, this
Yes.
other shooting of another prostitute?
Yes, and a little tangential information about another incident in Lawrence where they were trying to connect my client to. But none of that came in at trial, but this is kind of setting the background for the coerciveness of the statement. So the other information that that Rosario imparted to the defendant was basically telling him, this is your opportunity to tell me what happened. This is your opportunity. If you do this, basically, it will help you in the end. To quote it, at one point he says, listen to me. As I told you, you are going to reach a point at which you're going to realize that this was your opportunity to tell the truth. And I suggest to you when Rosario said that, he was really misstating and misinforming my client about his rights, because even if Ms. Edwin Rosario did not talk at that time, he clearly still would have had the opportunity to testify at trial, which is a fundamental right that he has. And by saying this to the defendant, he was really misrepresenting his rights, and he was manipulating him to think that if he didn't talk now, he wouldn't be able to tell his story later, which is something that the courts have actually reversed cases on, Commonwealth versus Novo. And in that case, the court talked about a detective who was questioning a witness relative to a child's death, and basically said, it's now your opportunity to say what happened, or you'll never have that opportunity. And the defendant understood that to be, if you don't talk now, you'll never be able to talk. And in the circumstances of this case, and that wasn't the only snippet where that tone and that information was departed to the defendant. But given that, that was another piece, Your Honors, that the defendant maintains made his statement not voluntary.
Right, so April, you've got these two interviews. What's the time difference? Did he just stay at the station, then they restarted
Yes.
the interview a second time? So
Yes. They took a break, and then I don't think it was a significantly long break, but they did break. Then they went back and talked.
And when the second interview was done, he was returned to the House of Corrections?
Yes.
And he was serving a sentence there?
No, he was being held on a matter pending in Worcester. I think it was an indecent assault and battery, but it was another separate matter that he was being held on.
Also a detainer
I
with
don't-
respect to his deportation or anything of that sort? I
No,
mean,
there was
he's-
nothing in the record that indicated any type of
Okay.
detainer or anything
All
like
right, so
that.
he's just being held at Worcester in connection with another criminal matter pending someplace
And then
else.
they bring him in.
So he's brought back there, and then they bring him back in May?
They do. And there are a few other things that happened in the April 29th conversation that I would suggest would, falls into the category of the May statement having his will be overborne. During that conversation, the Hispanic or detective keeps calling the defendant brother. Brother, if you do not say anything, you will be the one who will pay for this. Do you understand that? If you did not kill that woman, how come is it you remain silent when Julio was the one who did it? So really, he's really pushing him on his right to remain silent. And when you couple this with the misinformation he had, that if you don't speak now, you won't have a chance to speak, I suggest you, for the non-citizen defendant who's in custody, windowless room, that this is really resonating strong for him. And I think what's important is it's really misleading and misinformation.
So if Rosario, I mean, if the defendant understood Rosario to say on April, what was it, the 29th?
29.
If he understood Rosario to say, you got to tell me now or you'll never have another chance again, that's the understanding.
Yes, I think that is an interpretation
So why
of
did the
it.
defendant then call Rosario or make contact with Rosario to come in and give another statement in the middle of May?
It's actually unclear, I would suggest to you in the record, as to how it came about that this second conversation took place. I think there was findings by the judge indicating that he thought that the defendant somehow initiated the conversation, but I didn't really see that in the record, so I still think it's kind of speculative as to how that second conversation take place. I do know that I believe that the defendant was arraigned or shortly after the second conversation took place, and during that second conversation is when he did indicate that he was at the scene with Rosario.
Okay, but assuming that Rosario was the one that arranged to have the defendant brought back in, why aren't the first words out of the defendant's mouth? I thought something like, I thought that the only chance I would have to give a statement would have been in April. Why are you bringing me here?
Well, I would suggest because his will was overborne. The other thing I think that,
But the time had come and passed.
well, he's sitting,
That way the judge the judge actually discredited Rosario's explanation, didn't he?
Rosario's explanation, or the defendant's?
The defendant's explanation.
Yeah, yes, and I would suggest to you that you don't necessarily have to accept the judge's findings because these were recorded, and because they were recorded, I would suggest that this court is in as good a position as the judge was who heard the motion to suppress to decide whether or not the statements are voluntary or not.
Did the defendant testify at the motion to suppress hearing?
He did.
So that's something that's a credibility determination that the judge made, isn't it? Based on the defendant's testimony?
I mean, it is a credibility assessment, but I would suggest to you that because it was videotaped, that again, this court is in as good a
What was
position.
videotaped?
The conversations.
But I'm talking about the defendant's testimony about the
Oh,
conversation.
at the motion to suppress?
Yeah.
No, that wasn't videotaped. It was, you're right, that was part of the transcript, and that the judge said he didn't believe it. But I would suggest that there was more evidence, and I'd suggest that that was not supported by what happened in the April interview. One
Can I
other.
just go back to that?
Sure.
And just, I mean, we do have that both, but based on the transcripts, you describe a situation which it sounds like he doesn't know what his right to an attorney is, and then if you keep reading the transcripts, though, it's apparent that Detective Rosario was confused about the question, and then explains. Then explains that he has a right to an attorney and he can stop talking, and that's what it means. So it's clear from that context at page 86 of the appendix that he initially didn't understand what the question about an attorney meant. He said, oh, okay, you can give up the right and you can remain silent. So if you decide to answer, you can stop at any time and consult with an attorney. Do you understand more or less? Yes, I understand. So, you know, now he says he understands. I mean, he's been arraigned before, so he's had these Miranda before, I guess, at this point. And You're looking confused.
No, well, I guess when the Detective Rosario was saying more or less, you understand more or less, I mean, I would suggest what that indicates is even Rosario's not sure that the defendant is understanding what he's telling him about an attorney. I mean, this isn't a situation where it's, oh, do you understand your constitutional rights more or less, let's move on. I mean, I think that his right to an attorney is such a significant right. It's a fundamental right. It's not something that he has to understand more or less. I suggest he should understand it. And another part of that interview on April, I would suggest that indicates Rosario is just kind of taking the ball and running with
You
it.
read, if you hear it, it's more or less, not rather, do you understand more or do you understand less? It's more or less?
I mean, I don't think it matters what the inflection is or what the tone is because the standard really isn't more or less. I
No,
mean,
the question is
you
whether he
should-
now understands enough to proceed, and he says, yes, I understand. That's one way to, at least on the cold record, but I don't want to detain you. if you-
Sure.
I'm
No,
just-
I understand.
Seems like there's a little more in the transcript.
There is. There are other areas, but one other part is when between the first and second interview in April, when the parties come back and Rosario says, you want to go on, and he says, no, no, no.
Now,
And
that's actually not as clear as that, is it?
he says 3 times, no, no, no. I mean, the defendant says 3 times, no, no, no. And then Rosario says, well, I want to keep talking. And then they continue to talk. So I just think that the impression that leaves, I mean, there are 2 times Rosario has the opportunity to take the time to make sure that this defendant, who's in he's in a tough situation. He's not from this country. He didn't speak English fluently. I understand that the interrogation was in Spanish. However, the circumstances of what's unfolding around him, it's still intimidating to be in this country, not a citizen, being accused of this crime and being questioned in this manner. So I suggest that when you take all of the factors into account, it's the defendant's position that the statement was not voluntary. The Miranda rights were not voluntary because he didn't understand the issue relative to an attorney, and that the statements from April 29th and from May should not have been admitted at trial.
If I can turn you to the issue of sufficiency with regard to penetration.
Yes.
Was there blood inside the vagina?
There was blood inside the vagina. However, I would suggest that it was unclear how it got there, when it got there. The testimony from Dr. Budnock was that there was injury to the external genitalia that was consistent with rubbing or chafing or scratching, and she could not testify as to the timing of when the chafing occurred. And there were actually no injuries per se inside of Miss Livy's vagina.
And whose blood was it? Was it hers?
I think human blood is my understanding.
There was no indication as to whose blood it was.
I don't recall that, but I would. I don't want to misinform the court, so I'll have
Any
to.
discussion as to the amount of blood? Was it just
No, it was just blood from they did a swabbing and they did find blood, and they found blood going down her leg, so to speak, that they used to argue that she was standing at some point.
Was there evidence that the defendant had actually had sexual intercourse with Nettie?
I suggest no, Miss Libby, no. I would suggest.
But didn't he make a statement to Rosario to the effect that he didn't say it directly, but that he had intercourse, but he said he withdrew and then Mancius, whatever his name was, the
Yes.
other guy, took her into the woods.
In the context when he said he withdrew, my understanding of reading that part of it wasn't that he withdrew from her, but he withdrew from the situation.
Wasn't there
And
some-
left.
But could it have been, how was it argued to the jury?
From the defense from the prosecution point of view?
Prosecution, yeah.
The prosecution relied on, and I'll get into that in the closing, but basically relative to penetration, they didn't argue per se that the defendant said he had intercourse with Miss Libby. They relied on the DNA evidence on the condom and the pubic hair in her battered state to say that there was a rape and that actually it was done in the course of the beating.
Was there any scientific testing done on the type of cells from Nettie that were on the condom as to whether or not the cells were epithelial cells or whether they were from inside her vagina?
No, just that she
There was
was a
amylase.
major, I'm sorry?
It was amylase, is that how you pronounce it?
That's saliva, yes.
Well, it could be saliva, it could either
Or
be
it could be bodily fluid,
sweat,
sweat,
urine.
yes.
So it could be that the exterior, which included her as a minor contributor,
Contributor.
that could have been her sweat or other fluids from at least a partial penetration.
Well, I suggest that's speculative, just because there was no
How else
science.
did it get on there?
Well, there was testimony that there could have been wearer DNA, that, in fact, when you put a condom off, or put one on and take it off, that obviously
him
there's
put it on?
wearer DNA. There could have been, and that is the defendant's position, that the use of a condom actually in many situations does suggest consent, not non-consent, to a sexual activity, particularly in this case where the victim was, there was evidence that she was a prostitute. So the fact that there were cells on the condom does not, I would suggest to you, indicate that there was penetration, particularly because the evidence from Dr. Budnock was that you could not determine that there was penetration. Any injuries that she had to her external genitalia was, they couldn't say if it was consistent with consensual or non-consensual contact. So I would suggest that the DNA on the condom, and the defendant said himself that when he went down there and she asked for money, that he then turned around and left. And that was what Your Honor, Justice Spina was talking about when he said he withdrew. And then the Mr. Mancius went down, and that is our position of when the murder actually occurred. So I guess I'm done. I didn't want to
Time is
get
up. I do have one last question, unless my colleagues have another. The closing argument.
Yes.
Did the prosecutor say that Dr. Bundock had said that the injury to the vagina and then later injury to the labia occurred at the time of the rape, or did he or she say simply that that's what you should infer?
What he said was, what we have in the area of Maxine Libia's vagina, fresh abrasions to the labia, they aren't days old, these aren't weeks old, these are recent injuries. These aren't from scratching herself, these aren't from rubbing herself, ladies and gentlemen. That's the prosecutor saying what his view of the evidence is, not that Dr. Budnock said that. So no, and I think that when you couple that in his overstatement of what the injuries were to the vagina, that I think indicates that he recognized that penetration was very thin, and then he ends with the comment about, they treated her like she was litter, just like the litter we saw when we walked the scene. I suggest to you that was clearly just appealing to the emotions to get over the fact that he realizes he has a problem with the penetration, and you really need the penetration in this case because he was convicted on felony murder, and I would suggest to you that without the penetration and the aggravated rape, then we don't have felony murder.
You have felony murder second degree for indecent A and B?
Well, they didn't come back indecent A and B, and that was, I believe, an option given to them, but you could have straight felony rape as opposed to felony aggravated rape, which is why, another reason I'm asking the court, that based on the facts of this case, and when you compare the defendant's participation vis-a-vis other defendants who are convicted of first-degree murder, our position is that he was more passive than the evidence showing that he was the actual aggressor, and we're asking that if the court denies a reversal, that they consider, that you all consider reducing it to a lesser verdict.
Thank you.
Thank you.
Good morning. May it please the court, Susan Oftring on behalf of the Commonwealth. I'd like to begin with the first issue. The defendant raised in his motion to suppress and again the motion in limine basically the same issues that both the trial judge and the motion judge rejected, that the defendant was not coerced in I'll refer to it as the second April 29th, 2010 statement. He denied knowing the victim at that time. He denied speaking with Walter Martinez, who was the gentleman that testified at trial, and he certainly denied any involvement in the rape or murder of Libby.
Did the defendant specifically identify the April 29th statement in his original motion to suppress?
He did, Your Honor. He relied on that heavily.
Yeah, I mean, in the written motion to suppress.
Yes, and that's part of the record. Most of his reasoning was what happened in the April 29th interview. He was trying to suppress the May 17th statements. And the most.
But the judge addressed both statements in his decision.
The judge did, Your Honor.
Was he looking to suppress anything in the April 29th statement?
He was with his motion in limine at time of trial. So his motion to suppress was trying to suppress the third statement, which was the May 17.
The pretrial motion to suppress was to try to suppress the May statement only.
Correct.
It wasn't until trial that he tried to suppress the April 29th statement?
That's correct, Your Honor.
Okay.
But that's why I asked you whether he specifically identified the April 29th statement in his original motion to suppress, and you said that he did.
He specifically identified it as grounds to suppress the May 17th statement. He focused on what happened during that April 29th.
But he wasn't looking in his original motion to suppress the April 29th
That's
statement.
correct. That's correct. And the judge asked him during the motion to suppress hearing, are we here just on the May 17th statement? And at that point, according to the record, and defense counsel thought that the Commonwealth was only looking to introduce the statements that were made in the May 17th.
So why did the judge address both the April 29th and the May 17th statements in his memorandum of decision?
Well, I believe he did, Your Honor.
But why? If the defendant wasn't looking to suppress the April 29th statement?
Because the issue was the defendant coerced? Was it an improper tactics that the police conducted in the April 29th, 2010
That would have
interview?
tainted the May.
Was it voluntary or not? And the judge said, in the context, and I'll clarify, the judge had all the interviews that were recorded, granted they were in Spanish, but also the transcripts of all three interviews, the first April 29th, the second April 29th, and of course the May 17th. But he concluded that I find the religious comments, when taken in context with all the circumstances surrounding the interview, did not affect the voluntariness of the second or third statement by this defendant.
Was there anything in the May interview that the defendant complained of as being coercive?
I don't think so, Your Honor.
So trying to suppress the May statement on the basis of having been tainted then by the April 29th statement, it was only the tactics in the April 29th interview that were complained of.
That's my understanding.
So the statements about God and the statements about speak now or forever hold your peace, they all occurred on April 29th.
Correct.
And none of them occurred on May 17th.
Correct, Your Honor. In the May 29th statement, the defendant...
April.
Thank you, Your Honor. On the April 29th, the second statement, the defendant denied everything. But at that point, after that interview, the police, of course, had told him, listen, this is a crime scene. We found some evidence. We're going to get your buccal swab. At that point now, the defendant leaves, comes back on May 17th, and it is not clear from the record exactly how he came back. I do note that the motion judge found that how this interview was arranged is unclear from the record. However, the court infers and assumes from the record before me that the defendant, who is still in custody at the Worcester House of Correction, requested to speak with the police, and arrangements were made to bring him to the police station. When the defendant comes in on that May 17th interview, he now has been thinking about what The police have told him that they found, they started to give him more information about this murder of the victim. He knows he's given his buccal swab, and now the defendant starts to give the police a little bit more information.
Is it in the record that there was an intervening event, namely the giving of the buccal swab between the two statements?
It is, Your Honor. I think it's even mentioned in the April 29th interview. The police say, you know, when you're leaving here, we have a court order, we're going to take your buccal swab, and that could give us some details. So when he appears in May 17th now, he starts in a calculated effort to say, okay, I told you before when you show me the picture of the victim that I didn't know her. Well, I did know her. And I will note for a moment that that piece of information is the only statement that came into evidence from the April 29, 2010 interview. The prosecutor tried to get in more statements that were from that interview, but for other evidentiary reasons, the trial judge excluded them. The only piece from that April 29, 2010 interview that came in was when the police showed a picture of the victim to the defendant, and he said, I don't know her. Are you sure? Yeah, 100% sure, I don't know her. Well, now on May 17th, when he comes back in, that's the first thing he says to the officers, okay, I lied then, I did know her. Julio is the one who killed her, I had nothing to do with it. And as the police kept saying, well, we don't believe you, we have more evidence, he said, well, okay, I was there, I went with her first. She wanted money. If you find something on her, it's because I hugged her. And they asked for more details. And he said, well, all right, I lay down with her, I hugged her. At the very end, he now says he had a condom on, but when the victim asked for money, he stopped, and he said he withdrew, he went away, where Julio came in.
He said that he helped Julio move the victim's body to the railroad tracks.
That's correct.
Right? So if they moved the body, did they also move the rocks that had his DNA, Julio's DNA and the victim's DNA? And why would they move the rocks?
The evidence came in through Walter Martinez, who lived in the same house, which was in the same vicinity as the crime scene. Walter Martinez testified, Rafael Martinez testified, the father, son. The defendant and the co-venturer, Julio, all lived in the same house at 59.5 Benefit Street. Walter...
Yeah, were the rocks found near the body?
Yes, yes. The original confession from the defendant to Walter Martinez was a month after.
We moved the body.
I was with Julio. He killed her in the basement. I helped move her body to the railroad tracks.
And did he make a statement to Rosario to the effect that he helped move the body?
Rosario asked him, well, when Rosario, if you look at the interview, kept saying, especially during that April 29th, well, we know something happened in the basement, the defendant would say, nothing in the basement. Well, we know something ugly happened in the basement. And he would be very particular and say, well, no, not in the basement. So as it went on, and in the May 17th interview where he came a little bit more forthcoming about his involvement, he still said nothing happened in the basement, it all happened down by the railroad tracks. That's where the rocks were used, that's where the rocks were found with blood on them in the
What was the Commonwealth's theory about where it took place?
The railroad tracks.
It all took place at the railroad
Yes.
tracks where the
Yeah.
rocks were.
That's right.
And what do you say is the evidence that would show that there was rape, apart from penetration? Because there was a view that she was a prostitute. So what is the claim? What's the prosecutor's evidence here that this was a forcible rape?
The evidence, Your Honor, there's several points I'd like to make. The victim was found without her pants or underwear. They were missing. That, I believe, is evidence of a lack of consent and supports.
But his story is they had clothes off and he went on top of her and she said, I want you to pay? And he says, Mancius will pay, and she says, no, I want the money, and then she says no. What do you say happened?
What happened is the defendant and the co-venturer wanted to have sex with the victim. They went down to the railroad tracks. They, one or both of them, and we know from the condom, the swab of the interior of the condom matched the major profile of the defendant, and the victim was a potential contributor to the minor profile on the interior. On the exterior.
Right, well, that's, I don't quite get what that shows. If it's on the interior of the condom?
Well, we
What-
know the
what-
defendant had the condom on. He
Right,
admitted
okay,
that-
let's assume that he was wearing a condom and that she in some fashion touched the condom, but he also said that he was on top of her. He was embracing her.
He did everything.
So she would have touched the condom if they were both, she said, he said she was naked.
Right.
I'm not sure whether, I'm not sure whether he was in part naked, so there would have been touching of the condom.
Well, to have the condom, I think the jury can reasonably infer from the DNA found on the inside of the condom and on the outside of the condom, the major profile being the victim, that it's one evidence of penetration, in addition to the expert's testimony of a recent injury to the exterior genitalia, indicating could be consistent with force or penetration.
But I'm trying to, she was hit over the head in order to induce her to have sex? Is that, but that's not, no one describes, when the hitting over the head appeared to be continuous until she died. It doesn't appear as if that was to induce anything. It appears that was.
Well, it could have been any order of events.
Well, I understand, but I'm trying to figure out exactly what the evidence would permit, because I'm not sure if I see what the evidence is that the use of force to induce her consent here under the circumstances.
Well, the defendant admits that he went with the victim with the purpose of having sex. He took off his pants, she took off her clothes, they lay down, he put on a condom, he denied having sex, but I think the jury, from the testimony of the expert of some recent injury, as well as the DNA on the condom, could infer that there was penetration. At that point, a lack of consent when the victim wanted the money, whether the defendant, and he admitted he had no money, and she said, we're going to stop. Now Julio comes in and...
So I'm sorry. So it would be sufficient, it's rape if somebody has sex with a prostitute and then doesn't pay?
Well, she's now leaving. That's when they take the rocks and hit her and strangle her. There's evidence that she was also strangled. When she's hit with the rocks, the evidence, and the prosecutor argued, and the jury is free to believe, that she was standing at the time the rocks hit her.
Yeah,
and
so
struck
she had
her.
gotten up,
Right.
and with the time that she was struck, you say, she was naked.
Right.
That's another part that I have trouble with. She was found with shoes and socks on and a sweater and a shirt on. You're saying she was, at one point, she was naked when she was struck, and then they put clothes on her?
No, I'm just saying she was naked from the waist down.
The waist down.
Because they may have, at that point, already raped her, and she was trying to flee, and they struck her to prevent her from fleeing. And she was found without clothes on her. She was found with her legs spread open. It could have been that they disabled her, they struck her, she fell, and now they may have raped her after the blows were struck. But it's clear that it was a continuous event from the time...
So the argument is that she was raped, and the killing her was designed to guard against her, who was a prostitute, accusing them of rape? The
Commonwealth's theory was that she was raped either before or after she was struck with the rocks. She clearly had,
After, I mean, is that really the Commonwealth's theory, that after she was struck by the rocks, then she was raped?
that was a possibility, because she was struck while she was standing. She was obviously alive, but she didn't have clothes on because the way the blood dried indicated that she was already bleeding by the time when she was standing, and she was lying on the ground. The blood drops dried in a vertical pattern, so she was on the ground now after being struck, and the rape could have occurred by one of the two men after she was struck to compel her to submit to their.
Did the Commonwealth
attack.
argue that theory at trial? Intercourse with a comatose person or a person who was unconscious?
There was no mention at all about whether she was conscious or unconscious. The argument was it was under the one of two factors for aggravated rape, that it was committed by a joint venture or infliction of serious bodily injury. I believe when...
Was there any claim that Mancius had sexual intercourse with her?
There was no claim specifically that either from the defendant, or I suppose the defendant said that Mancius went with her. Mancius was with her, so he implied that Mancius had some type of sexual relations with her. But as far as the forensic evidence, I don't think there was anything.
Did the Commonwealth argue that Mancius had intercourse with her?
Not that I could think of, Your Honor. But again, it was a joint venture.
So if there was an aggravated rape, it depended upon intercourse between the defendant and the victim.
The jury could have found that, but I think...
Well, they would have to find that.
Well, I think the jury could also infer that in terms of penetration and intercourse, it was most likely that the Commonwealth argued that it was this defendant with the assistance of Julio, whether he assisted by hitting her with rocks to compel her to submit to the defendant.
How
That
is the
could have been a
joint venture
theory.
or the joint enterprise, if they're the same? I don't know if you think they're the same. How is the joint venture piece argued? So, and how do you think it fits within the concept of, at least one of our cases suggests there had to be unified action. Does it require more than an intent to commit the crime of rape as a joint enterprise?
It does. That's what it requires, so intent to commit the aggravated rape.
Was
By
that the
one or two.
argument, that they intended to rape her? They intended not to pay her?
Yes, yes. And to expand upon that, for the joint enterprise, there was evidence from these other witnesses, Raphael and Walter Martinez, that these two gentlemen, the defendant and Julio, were close, were always seen together. They were seen 11 o'clock that night with the female. 2 or 3 hours later, the two men showed up at that shared home that they shared with the Martinez, knocking on the window, asking to be let in. And when they were let in, they came in, the witness, I think, said, in an agitated state. They came in running, they went right to the room and closed the door. So even in terms of the timing of it, they were seen with the female before. They fled from the scene. There's evidence that they were fleeing in a joint venture to escape from the crime.
What were the theories of second-degree murder that were presented to the jury, or in the judge's instructions?
The theory of second-degree murder was that if you don't find aggravated rape, it's second-degree murder.
You mean second-degree felony murder?
Right.
But if there was what, attempted rape or rape?
If there was rape without the aggravated, if it wasn't a joint venture or you didn't find infliction of...
Or if there was indecent sexual
Right, and they were
assault.
also instructed.
Both of
not-
those would be second degree.
What were the defendant's statements to that other individual? What was his name?
Martinez?
Were those admitted?
They were, and that's where I was going, Your Honor, thank you. the defendant admitted 1 month after this murder to Walter Martinez that he and Mancez had been with a woman and that they had killed her. And that was the quote, the exact words from this witness. The defendant demonstrated for Mr. Martinez how Julio used the rocks to strike the woman in the back of the head, and that's when he made the statement that he helped to move the body. Martinez testified that he later then went to Julio, who, as you know, by the time of trial had died, so he didn't testify, obviously, but he had told Martinez when confronted with this admission by the defendant, said, yes, that is all true. In furtherance of the joint venture, the defendant did admit that he was there. He saw the defendant, saw Julio strike the victim with rocks, and he was asked to be on a lookout for police. So he aided in this joint venture when...
But what do we do with that when the jury did not find him guilty of extreme atrocity or cruelty? I mean, let's assume, I gather there is evidence that's sufficient to indicate that he was there, that he saw his Mancius go, and he saw Mancius strike her repeatedly with a rock, and he said, he asked me to look out for the police. So you would have joint venture, but in the absence of a sexual assault, what do we have? I mean, I know you claim that there is sexual assault, not me, but so let's imagine the possibility that there would be a concern about that. We have a strange situation where there's adequate evidence of a joint venture murder, but the jury didn't find, but it was not asked to find premeditation, and it didn't find extreme atrocity. It found only felony murder. So what do we do? What do we have in that situation?
Well, if I don't see, Your Honor, and I apologize if I don't understand, but if you don't find any sexual penetration and you don't have extreme atrocity, then I don't think there's anything you do with that about the rocks and watching that, other than it goes to the joint venture. So if you find that Julio was the one who struck her, this defendant was part of that joint venture. He was on the lookout. He contributed to it. He aided in it and assisted in it. But in terms of the aggravated rape, I think that was the point, is from the beginning, during, and the end, these two men were in it for the sole reason to commit an aggravated rape on this victim that led to her murder, and therefore the conviction should be upheld.
All right, thank you.
Thank you, Your Honor.